there was a question about what tools the court uses when looking to understand what voters understood. And the Voting Restoration Amendment case provides a clear example of that. Part of what the court did in determining what the ordinary understanding was likely to be was looking to contemporaneous case law as part of that plain text and ordinary meaning analysis. Here, the contemporaneous case law in 1980 unequivocally provided protection for the right to abortion as part of privacy rights and the Privacy Clause's terms. I would also underscore that the question here, in light of the stare decisis analysis, is whether the prior conclusion that abortion was included was clearly erroneous. And here, in light of the plain text evidence and in light of the established meaning in 1980, it was at minimum reasonable for the prior justices of this court to include that it was, and that counsels in favor of this court adhering to precedent. In fact, not only was the TW court unanimous in concluding that the Privacy Clause protected abortion at least as strongly as under Roe, no justice of this court has subsequently written a decision calling that conclusion into question. And I think the weight of those considered judicial judgments provides clear evidence that the prior conclusions were indeed reasonable and fall far short of the clearly erroneous standard. I also want to address the state's argument to limit the clause solely to informational privacy. This is a completely atextual reading of what the Privacy Clause said. The state would have this court read it as if it protected private information from government snooping, and that is simply not the words that the Privacy Clause uses. In cases like Voting Restoration Amendment, the court refused to narrowly construe the phrase terms of sentence to exclude legal financial obligations where the text itself doesn't do so, and that's precisely the case we have here. Nothing in the text excludes decisional autonomy rights like abortion from the otherwise broad protections. The state mentioned the second sentence, and I just want to underscore that Voting Restoration Amendment also dispenses with that argument. That case made clear that a specific term only narrows a more general term where it precedes it, and that is not the case with the Privacy Clause. I want to speak for a moment also about the implications of the state's argument that the clause is limited to informational privacy. As the questions recognized, this would have a destabilizing impact on numerous other areas of this court's privacy jurisprudence. This court has repeatedly applied the Privacy Clause outside of the informational privacy context in areas such as parental rights and medical decision-making. Many of those cases did rely specifically on first and foremost on the Privacy Clause under the Florida Constitution, not under the federal protections. And moreover, this court has repeatedly held that the Privacy Clause is broader and more protective of those rights than federal law. So the Florida Constitution's protections for decisional autonomy are not at all duplicative of federal law. And if this court were to accept the state's argument, it would have a destabilizing effect on all of those other rights that this court has held to be independently protected by the Florida Constitution. With respect to standing, I wanted to note that the state referred to the Kowalski decision, and I want to underscore that that decision specifically emphasized that in certain contexts, in particular where a third party's rights are harmed by the direct enforcement of a law against somebody else, in those circumstances, the third party standing inquiry is more forgiving. So if anything, Kowalski makes clear that in a circumstance like this, where the providers themselves are the ones that are directly subject to HB 5's severe criminal penalties and have a clear stake in the outcome of this case, the third party standing inquiry, if anything, is more forgiving, and the trial court's findings that plaintiffs satisfy it is more than sufficient to affirm. I lastly just want to address the state's suggestion that upholding privacy rights for abortion here would open the door for other things like infanticide. And frankly, there's no reason for the court to be concerned about that. This is not a brave new world. Abortion was recognized as a fundamental privacy right in Florida for decades. It has never been the case that has led to a free-for-all of according privacy right protections to criminal acts like infanticide. there's also a clear basis for this court to distinguish, because the privacy clause was unequivocally included in the established meaning, and that is simply not the case for these other extreme hypotheticals that the state has put forward. So for all the reasons...
Sorry, can I ask you about Dobbs before you finish? So you're asking us to essentially take a whole class of human beings and put them outside of the protection of the law, essentially in the sense that if the legislature wants to protect those human beings, they are precluded by the Constitution of Florida from doing that. And at the end of the day, the argument as to why that would be right would be based on a sort of legal meaning kind of understanding of right of privacy. We now know that, you know, the same entity that created that understanding of the right of privacy has told us that it was a mirage. They've eviscerated it. Should we take that into account when we're talking about the weighty interests at stake on both sides and the fact that this is a sort of democratic legitimacy type issue? Should it matter to us that the entire foundation of the asserted right here, essentially the Supreme Court, which created the thing in the first place, has now said that it was egregiously wrong from day one? I mean, should that matter to us?
No, Your Honor, and there are 2 points that I want to raise. First, I think I want to underscore that what would in fact be unique here is allowing HB 5 to stand, because there is no other context in which this court has held that the state can constitutionally force an individual to take on increased and serious medical risks and harm for the purported benefit of others. But that is precisely what HB 5 forces pregnant women to do. The protection for privacy rights in this court's precedent do balance those interests and recognize the state's interests in fetal life after the point of viability. With respect to Dobbs specifically, nothing in Dobbs, on its face, the court repeatedly emphasized this, nothing in the Dobbs decision displaces pre-existing state constitutional protections for abortion that were more protective than the federal law. And Dobbs repeatedly makes clear that indeed that's a core part of our federalist system, that states are free to accord that level of protection. And that is precisely what Floridians have done here. So for those reasons and all the other reasons stated in our brief, we ask the court to reverse the first DCA and reinstate the trial court's injunction. Thank you.
Thank you. We really appreciate the excellent argument and briefing today. We're adjourned.